sky. That's the
Welcome back to Give Me Some Truth. Today, Stan and I are going to talk about an important topic, one that I don't think is covered quite enough, because I think the numbers are still about 50% of our marriages end in divorce. Is that number still good? I don't know.
I think that might be a little low, actually.
Oh, boy, right? So, I mean, there is a situation where we have a lot of blended families out there, and there's a lot of nuance to planning. We're going to stay more on kind of the financial planning, estate planning side of things today when we talk about this topic. And we'll touch a little bit on international, because when we had the conversation prior to sitting down here, it was very enlightening for me to listen to some of the trip-ups that you could have on some of the trust planning if you do it domestically and then just figure it just applies internationally. And we found out it definitely does not. So we'll touch on that as well. But I think first and foremost, when we're dealing in a blended family situation, Stan, you know, and we have these two different or three different groups of people in here, if you're trying to go and set up your own financial planning, what do you think the most important thing it is to focus on when we're trying to do this?
That's a good question, Clint. But blended families, by the way, I mean, what we're talking about here is generally when, anything that breaks away from the traditional family of, two married people having a set of children, right? So, this hits home for me. I have 3 children from a previous marriage, and then I was divorced and I remarried, and now, believe it or not, my wife and I, after my kids became adults, we just recently had a baby boy. So now we have a family where there are 3 kids that are not my wife's kids, right? So I have 4 kids. She has 1. When it comes to the estate planning, the traditional to my wife, if she survives me, and if not, to my children, right, is more complicated, right? That's not how the that's an estate plan that may result in like the kids from the prior relationship, losing out, right?
That's right.
Or if you leave all your money, conversely, to your kids, take care of mom. They may not. You can look at it lots of different ways, but it's an emotional issue for clients. And and when dealing with clients, you want to proactively, point out solutions, but you also have to be cognizant of the fact that the two of them may have, different objectives, right, or preferences at the very least, when you're talking about how to plan thoughtfully for this. And so the main idea here is if you're listening to this or watching this and you're in a blended family relationship, just understand that it's going to require it's all the more urgent that you give it some proactive thought and do some concrete planning around how to best organize the distribution of your wealth when you die. But also think about how lifetime gifting strategies might also, fit into the picture and maybe, produce more optimal results for you.
Yeah, and you have an incredibly complex situation, and I think that obviously communication is key, but it's also a difficult conversation in many cases if you have competing interests.
It's a difficult situation. It's okay with me if neither my wife nor my kids ever listen to this podcast.
Yeah, no kidding.
I love it when they do, but if they don't on this one, it's fine by me.
Yeah, I mean, you have the kids' interests because you have grown kids, which makes it that much more complex because you have grown kids and then you have a little one with your wife, and that has all kinds of different ramifications as far as how you split up how you split up your assets, and whose assets are whose, and how you all see it as a family
Correct.
unit. Yeah. Your grown kids may say, well, we have a lot of, we should have ties to a lot of those assets. Your wife may say, well, our family unit should have a lot of ties to the assets, and then going and having a conversation with everybody. It's incredibly complex. I wish you good luck on that conversation, by the way. But yeah, I mean, and you now obviously have an event where estate planning really has to occur because you have a young one now.
Yeah.
And if, the two of you really, and that's the worst case scenario, if the two of you aren't there, how is care being provided to your young one? And then if one of you isn't there, how are you going to do that while also taking care of your other kids, if that is something you value?
Right.
You may not. You may say, we got him there and we got him out of the nest, and now you're out of the nest. But I can see a lot of nuance in that situation, saying, well, yeah, but, we should have a little ties to it. I'd want a little coin if I was them,
Oh, absolutely. Well, and you also, you touch on the idea that whose property is it, right? And so, you even think about the different nuances when you're in a common law jurisdiction where there can be separate property during marriage. Then you think about the property regimes that exist under civil law, and by that I mean even on the west coast of the United States and Wisconsin, right? You're in a marital property regime,
right?
So, how does that factor, and how does that limit, like, your gifting or you're passing on wealth to non-spouses, right? I mean, there's just a million different nuances to this. Now, domestically, Clint, I'm sure that, like you said, over 50% of marriages end in divorce. So there's lots of blended family clients out there. What are some of the solutions that are often appropriate under such circumstances in terms of the broader estate plan?
Yeah, I mean, the solution is really to meet with a qualified estate planning attorney that has blended family experience. I mean, that's the answer to that. But I'll share a little story myself about kind of a horror story. I've personally seen this with some family members, and what happened is there was a husband in a situation that passed away. He wanted to leave a portion of his assets to his child, but it was a marital property estate. And so he had a blended family, and his wife at the time, they wanted to do that possibly, but he did not disclose to her, and she did not sign off on the spousal consent form. Mm-hmm. So, essentially the assets got passed all to the spouse, even though he had intentions and thoughts of passing it to partially to his son. So his son actually ended up with nothing in that situation. And it was because they didn't have a conversation around it, and they didn't sign off on the form.
Right.
And if you don't have it, the courts don't care. The courts are going to execute to the documents that are there. And if there's something that's missing, like a spousal consent signature, it's not going to happen for you. So, those are things to be aware of on the pitfalls. There's a lot of legalese. And think about if that got fought in court, how much money would be spent in trying to interpret all of that and try to get that facilitated, where if you take the planning up front and everyone's aware of what's going on, well, then that's what it is. And you can avoid some expensive lawsuits over that and a lot of back and forth. And also, you always want to, if you can, probably try to avoid probate at
right.
most cost. For people of means that have built up wealth, you want to avoid probate, because probate's actually a lot more expensive than people think and just takes a long time.
Well, and that's the thing too, right? I mean, if you truly, worry about, the liquidity of, getting that wealth to people who may actually, need the help, right? that probate is kind of horrible. It's a time suck. It's a money suck. It sucks.
I mean,
basically.
how long have you seen? I've seen cases, even when it's flying through probate in quotes, it's like almost 6 months. I mean,
Right.
and I don't know if you've seen any super long ones, but I mean, there are ones that take years.
Well, yeah, and yeah, I mean, so the U.S. is obviously famous for its expensive health care and its dysfunctional legal system. I think those are two those are two titles that we have taken and it can't be disputed in the world, right? So yeah, I mean, probate avoidance is is a relatively easy construct in the United States anyway, right?
Right. I mean, and probate avoidance can be done relatively easily. Name a beneficiary on the account, and in most cases, that will pass through and not be a probate issue. And so,
Right.
when people say, "Oh, I got a will," that's all my stuff's going to go down. I got a will. Well, basically, the probate court's reading that will. It's not avoiding probate. If you have a will, if you're naming beneficiaries, it'll usually, circumvent that probate process. And that's why we always tell people in all of your accounts in the U.S., we'll talk about the nuance in a second of international, but in the U.S., if you have bank accounts, things like that you might not think about, always make sure there's a transfer on death or payable on death beneficiary on those assets, so that if something happens to you, that those assets are going to pass more freely to the beneficiaries that you actually name. And so same thing with IRAs. And if you get divorced, one of the first things that you should look at is, do you have some old policy? Do you have some old something out there that you might not have changed beneficiaries on, and all of a sudden somebody in your family passes away, and then the ex-wife that's not even in the picture anymore inherits a bunch of something that you didn't want to happen. So I think that would be kind of
that's always great advice. If you've been divorced, you've probably already experienced the great halving of your wealth. So you might want to make sure that it doesn't happen again when you die. Right?
I mean, that'd be the worst feeling in the world, right? If you're the beneficiary.
Probably not your intended beneficiary after that, right?
That's right.
So
I do want to talk a little bit about the international nuances of it, because you have particular expertise in this. So, I go, like right now, my family, we got a revocable living trust. We've named, all the people we got to name. We got our beneficiaries all set, and now we want to move abroad. And I think my estate plan is in wonderful shape right now because I have these documents.
Right. Well, I mean, so the first thing is, and I think if you're in a blended family, this is even more likely to happen. Like you go to this estate planning attorney who has experience in working out your strategic plan with regard to how you want to share your wealth when you're alive and then upon death, and quite often this is going to include trusts, right? And the wealthier you are, the more likely it's going to be, a more sophisticated trust. But like even just a plain old vanilla grantor trust that then, provides for a non-revocable trust upon death, but then kind of directs how the support is going to go from your estate, if you will, goes a long way. It avoids that probate, right? Of course, the ability to designate beneficiaries on non-retirement accounts has I think in many ways helped the common man out, because it kind of skips the lawyer or the grantor trust altogether. You don't necessarily need to go through that process to name beneficiaries, right? But being able to name beneficiaries doesn't necessarily resolve the blended family issues maybe the way that you would want to, right?
Mm-hmm.
So because it means 50% to wife, 50% shared by the kids, or some accounts to one, some accounts to another, where like your intention might want to be, well, I mean, I don't know how much I'm 36 years old. I'm not sure how much. I'm not even sure what I'm going to have when I die. What I do want to have is a general directive that would make sure that, maybe my kids get paid out, a little bit to, immediately, but otherwise the bulk of it is to make sure that my wife, continues to be, able to live comfortably. And then when I die, that all of my kids from marriage A, marriage B, whatever, marriage C, D, what, depending on your circumstances, just make sure that everybody that you would want to be taken care of gets taken care of in a way that you find to be equitable, right? Might be an objective. And trust would be the normal way to deal with this in the United States, I think, right?
Right.
Just straight naming beneficiaries doesn't take care of the multi-stage process of sharing, I think, that you might want in a blended situation.
If you're on like trustee, though, you probably have no money left anymore.
Well, I mean, here's how things really suck when you move abroad, right? When it comes to this particular issue, I think, in particular, like, there are some roadblocks here, okay? One is that just the simple being able to name beneficiaries on accounts and avoid, probate or whatever process you're going to be subject to, that goes out the door, okay? It was a uniform state act that created the ability to bypass probate and name direct beneficiaries on non-retirement accounts, right? And that came around, a decade ago, 15 years ago, right? That was enacted by 49 different states, every state except Louisiana. God bless you, Louisiana, for just being you. Taking a stand against this ridiculous
How dare you name a
process.
beneficiary?
Right. But I mean, the funny thing is that you have U.S. accounts in your U.S. bank or your brokerage, and you may have actually named beneficiaries in your accounts and then moved abroad. But guess what? I got some bad news for you. Most banks and brokerages aren't going to recognize the transfer on death beneficiaries if they discover that you lived dying abroad, okay? And I don't want to spend a lot of time on this for the background as to why, but I mean, when you think about it, estate planning law is property law. It's about transfer of ownership, right? And property law is a local construct, which is why every state has to have this TOD law in place for you to be able to securely enjoy TOD. Whereas if not, if you move to one state to another, it may no longer be valid, right? But moving abroad is like moving to Louisiana, apparently, when it comes to this, right? So there is no longer you're now a resident or domiciled elsewhere. You're no longer in Wisconsin. We're not in Kansas anymore, Dorothy. We're in Luxembourg or whatever, right? So that law upon which the beneficiary designation was authorized no longer applies to your account, right? So it matters where the decedent lived when they died, ultimately. If your kids move abroad, your TODs will still work for them, by the way. I mean, like, it's where the decedent lived and the account owner, So if you go abroad, you don't have that. And you probably, without a doubt, you must get some legal advice wherever you have lived in the world, wherever you're now living or before you even move there. If you've done a trust around these issues, a U.S. trust may quite possibly create huge problems for you, right? Or your heirs, or both, right? It may trigger income tax that would not otherwise be triggered. It may trigger inheritance tax or estate tax that would be much higher in the jurisdiction that you're living in, right? Trusts aren't necessarily recognized in foreign jurisdictions. Trust law was created in the United Kingdom. It's common law. It's a common law entity. And so while the Great Britain had its trust laws, and we developed our laws through that, we have our trust laws. Other countries that practice civil law, Sharia law, basically every legal system except that kind of the British Commonwealth in the United States, really don't have a legal culture of where the trust is accepted as a separate legal entity, right? So this creates all kinds of mad confusion for expats. And generally, as a rule, I like to let people know that your U.S. domestic trust will not travel well. Okay, there are exceptions. I mean, if you're in a country that doesn't tax your offshore wealth, right? You can live there and they don't care what you own outside of there. Then it may continue to work, right? So, but if you live in a country like France or Italy or Germany, don't count on your U.S. trust. Don't count on it performing as anticipated, and it might jack your income tax rates, or it might jack the inheritance tax that would be levied after you die. If it's going to be administrated and distributed via a trust instrument instead of via succession or probate. So that was a mouthful.
Well, you should definitely, obviously, you need to find an estate planning attorney then in wherever you're domiciled then.
Yeah.
As well.
Yeah. I mean, and really then, like if you can't utilize the trust, and it's going to be the country rules where you live, then you have to, you're gonna need some guidance. Right. I mean, we do our best to help clients all the time, find the right legal expertise, but let them understand, kind of conceptually, what your options are, or what the obvious options are. And then, any more complicated schemes we would leave to the legal profession, of course, to devise.
Of course. Well, this has been that's a really enlightening thing with the international side of things. I wasn't aware of a lot of that until you shared it with me earlier. So we'd like to thank everyone for joining us in this blended family podcast. And anyone that has any questions, feel free to send those in, and we'll do our best. Any comments on the episode, we'd appreciate that. And if you haven't subscribed yet, subscribe, and you can hear more on this. I know we could probably do a couple more podcasts just even on this topic, because there's investment strategies as well and other things that could be talked about around this topic. So if you have any, please leave in the comments, and we'll see if we can develop episodes off of that going forward. So thank you for joining us on another episode of Give Me Some Truth.
Walker Condon Financial Advisors is a registered investment advisor with the SEC. Registration with the SEC does not imply a certain level of skill or training. The opinions expressed by the participants of this podcast are their own and do not reflect the opinions of Walker Condon Financial Advisors. All statements and opinions expressed are based upon information considered reliable, although it should not be relied upon as such. Any statements or opinions are subject to change without notice. Information presented is for educational purposes only and does not intend to make an offer or solicitation for the sale or purchase of any specific securities, investments, or investment strategies. Investments involve risk and, unless otherwise stated, are not guaranteed. The information expressed does not take into account your specific situation or objectives and is not intended as recommendations appropriate for any individual. Viewers are encouraged to seek advice from a qualified tax, legal, or investment advisor to determine whether any information presented may be suitable for their specific situation. Past performance is not indicative of future performance.
You gotta leave your money behind you. Raise your hand to the sky. Ask the masses for silence.